This is case number 254847 SM, the people of the state of Michigan versus Becky Lee Harp. Ms. Harp, do you read and sign this advice of rights form today?
Yes.
The contact information on the back of that, is that accurate? Yes. Did you have the opportunity to meet with somebody from the defender's office today? Did you meet with Mr. Hartel? All right. I have a complaint that alleges that on or about November 14th, 2025, in the village of Mesick of Wexford County, it is alleged that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties? You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one will be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney? And what is your current source of income?
I don't have an income. I'm doing split by family and friends currently.
Our court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show a 99 an MIP of alcohol, 09 a trespass, 11 a disorderly drunk, and 17 disorderly drunk. Those have all been automatically expunged from her record. The Praxis scores her at a risk level 2, so low risk. And a $500 bond has previously been posted. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. We would ask for bond to be continued. I believe that would be appropriate. As the court did know, she does not have a non-expunged record to speak of, and I do believe that she would obey any bond conditions the court wished to place on her. We do, of course, trust the court's discretion when it comes to no contact orders, things of that nature.
Thank you. Ms. Dahl, on behalf of the people.
Yes, Your Honor, I have serious concerns in this case. I would ask the court to consider a no contact with the alleged victim in this case, which is her daughter. I'm not sure if there's another parent or guardian available to take care of the child while this case is pending with a no contact provision. But it's alleged in this case that Ms. Harp used her elbow to hit her child in the face and left a red mark. And this is while it is alleged that she was drinking throughout the day and was intoxicated. So I'd also ask the court to do random alcohol testing and order that she not have any weapons or firearms.
Thank you. The court will continue the bond as previously set with the following conditions. Ms. Harp, you are to appear as ordered. Keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with Phoenix Harp. No contact means no contact of any kind, not by phone, text, email, social media, anybody acting on your behalf. Do you understand that? I'm also going to order that you not purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior. Because alcohol is believed to be a factor in this case, I believe it's appropriate to order a no alcohol provision. And although they've been expunged, you have 3 prior convictions for alcohol issues, so I believe daily testing will be necessary in this case.
What if I'm unable to because I don't drive, I don't have a vehicle, and I have no friends or family?
The daily testing, you'll take a device with you, and you'll blow into it. Community corrections will set the number of times that you blow into it, but there is a charge for that, just so you're aware. If you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. You understand that? You can go out to the front window where you checked in, get your next court date. You'll probably have some paperwork to the defender's office if you haven't already done that, and then you'll need to go downstairs to community corrections and get signed up for testing.
Okay.
All right?
Thank you.
Thank you. A person at the Missaukee County Jail, please state your name.
Persephone Bowman.
I'm sorry?
Persephone Bowman.
This is case number 254351 SM, the people of the state of Michigan versus Persephone Ann Bowman. Ms. Bowman, you are here for a bench warrant for a fail to appear at arraignment on October 30th, 2025 on a charge of retail fraud second degree. That retail fraud second degree is alleged to have occurred September 16th, 2025 in Herring Township of Wexford County. And it is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000 or 3 times the value of the property taken. Do you understand those charges and the potential penalties?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. My question to you today is, do you wish to hire an attorney, represent yourself, or request the appointment of an attorney?
I'll just represent myself.
All right. Before I allow that, I have to be convinced that the waiver of an attorney is knowing and voluntary. So I'm going to read something to you. So bear with me while I do that. All right.
Okay.
This form says that I am the defendant in this case, and the judge has explained to me, and I understand that I have been accused of a crime, and I have read or have had read to me the charges against me and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I have the right to be represented by a lawyer at all stages of this process, and the court will appoint one for me at public expense if I cannot afford one. That I have the right to consult with a lawyer that I hire or that the court appoints. That I have the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and will not get any special treatment from the court. The risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense in trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection, procedure, or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. Ma'am, how many years of education do you have?
I graduated high school.
I have 12 years of education. I read and understand the English language, and I am mentally sound. Having gone through all that, do you still wish to represent yourself?
Yes.
All right. Today we have a couple of options for you. One is to plead not guilty. If you pled not guilty, the matter would be set for a pretrial, which would give you the opportunity to discuss the issues that brought you to court with the prosecutor and see if there's a way to resolve the case short of going to trial. You also have the right to plead guilty. If you pled guilty as charged, the 1 year misdemeanor would enter on your record, and we would probably be able to sentence today. So my question to you is, how do you plead to the charge of retail fraud second degree, guilty or not guilty?
Guilty.
In order to accept that plea, we have to go through a process. Will you please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Ma'am?
Yes.
May you put your hand down? So it's my understanding you'll be pleading guilty as charged retail fraud second degree, which is the 1 year misdemeanor. Back on September 16th of this year, were you on probation or parole?
No.
Were you on bond?
No.
Do you understand that you had the right to have a trial by jury and to have witnesses called for your defense at the trial, to cross-examine all witnesses called against you, the right to testify or to remain silent, and if you remain silent, that silence could not be used against you. You also have the right to be presumed innocent and to be proven guilty beyond a reasonable doubt. By entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind. Do you understand that?
Yes.
Has anybody promised you anything in order to get you to plea today?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes.
Ms. Dahl, are you aware of any promises, threats, or inducements not made part of the record?
No, Your Honor.
Then Ms. Bullman, to the allegation that on or about September 16th, 2025 in Herion Township, Wexford County, how do you plead to reef trail fraud second degree? Guilty or not guilty?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on September 16th, were you in the, looks like the Walmart store in Herion Township?
Yes.
And did you attempt to take some property or take some property that belonged to the store?
Yes.
Did you actually get out of the store with those items?
No.
Where were you stopped?
At the first exit doors.
So were you in kind of the vestibule area or were you still in the store?
I was, like, I would say probably 2 steps out of the, like, in between area.
So where the shopping carts are parked there?
Yeah.
And would you agree with me that the items taken had a value of at least $200, but less than $1,000?
Yes.
What is it that you took?
Camping stuff. And, fuel for food.
And was it your intent to leave the store without paying for those items?
Yes.
Ms. Dahl, do you believe the defendants provided the factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Bullman, I find you guilty of retail fraud second degree. Are we able to sentence today?
Yes, Your Honor, none of the items, well, I'm sorry, all of the items were recovered, so there's no restitution in this case.
All right. Ms. Bullman, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
No, thank you.
What are you currently in Misaki for?
A bench warrant for a civil infraction for no insurance that I mixed up the dates on.
Have you been arraigned on that? Have you been arraigned on that yet?
No.
All right. But historically, in the defendant's past, I show in 15, there was an attempted operating without a license, in 18, 2 convictions for embezzlement. The defendant failed to appear in this matter on 2 separate occasions. So I believe placing the defendant on probation is not a good use of resources in this case. So it will be a straight jail sentence. There'll be 10 days jail with 1 day credit.
And there it is. The failed court appearances finally caught up with her. You could almost feel the moment she realized the judge wasn't giving another pass this time.
With 1 day credit. There is a $75 crime victims' rights fund fee, $50 state minimum fee, court costs, $150 fine. I believe jail is appropriate. Court fail to appears. I believe jail is appropriate. This is retail fraud second, and that there are prior facts that this is retail fraud second, and that there are prior Ms. Bullman, you do have, because I have sentenced you to a period of incarceration. Ms. Bullman, you do have the right to appeal that decision. If you decided that you wanted to appeal it, you do have the right to appeal that decision. If you decided that you wanted to appeal it, 14 days from today's date, to assist you in that regard. Appointment of an attorney. You have 14 days from today's date in which to request. Additionally, any balance that remains unpaid for more than 56 days will have additionally any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. Do you understand that?
Yes.
When you are released from the jail over there, you're going to need to get a hold of the jail over there. You're going to need to district court. Get a hold of either make here in Cadillac. Excuse me, make a payment or get set up on a payment. Either make a, excuse me, make a payment or get set up on a payment. Thank you, Misaki. All right. All right. Thank you, Misaki. Person at the Wexford County Jail. Please state your name for the record. Person at the Wexford. This is I'm Judge Wiggins in the 84th District Court. This is I'm Judge Wiggins for the 4th District Court. Bench warrant for fail to appear at a financial review hearing. Bench warrant for fail to appear at a financial review hearing. Sharon Road Southeast, your current mailing address? Is Sharon Road Southeast your current mailing address?
The letters that were mailed to me
Yes,
to my
the
letters
here
that were mailed to me went to my
East North,
address here at Cadillac to my parents' house, which now that's where I'm currently residing. To my parents' house, which now that's where I'm currently residing.
Okay.
But
And then is a phone number ending in 6408 still a good number for you? And then is a phone number
Yes,
ending
it
in
is.
6408 still a
I
good
show
number
that
for
you currently owe the court
Yes, it is.
$858.
I show that
The
you
last
currently
payment
owe the
made in
court
March. Are you able to make any payment
$858
on that today? The last payment made in March. Are you able to make
Currently,
any payment on that
have
today?
no way to make any money. Currently, I have payment, no way to make any money towards that today, like any payment, I have a vehicle I'm gonna sell and go pawn some tools as soon as I'm able to get out of here. And go pawn some tools as soon as I'm
Alright,
able
so
to get out of
Mr.
here.
Nason, what I'm going to do is I'm going to release you on a PR. Alright, so Mr. Nason, what I'm going to do is I'm going to release you on a PR. Oh, okay. So on the financial review hearing, I'm going to release, yes, sir. So on the financial review hearing, I'm going to release,
talk to
yes, sir.
Mr. Thomas. I was also, because he's a pretty understandable man, and see if we can come to a conclusion about the pretty understandable man, and see if we can come to an agreement about the money of dog that I owe him, or come to an agreement if I pick up dog when I come back here.
So I'm going to release you on a personal recognizance bond for, so I'm going to release you on a financial review bond for, I'm gonna set that in 3 months. Financial review different than the matter you have. I'm gonna set that in 3 months. Now that's different than the matter you have with Mr. Holsinger, and we'll get to that in a moment. We'll reset the financial review hearing in 3 months. So if you start making reset the financial review hearing in 3 months, not, we'll get you. If you start making a payment on it, maybe your financial situation hasn't changed, we get you on a payment plan. Maybe your financial situation hasn't changed, we get you on a payment plan. All right.
Or whatever.
That's for the 858.
Or whatever.
That's for the
I got different
858.
paperwork than you.
Well, so the 300 was, there was a bond set for $300. Well, so the 300, that $300 bond, and I'm going to allow you to get out of jail. I'm canceling that $300 bond, and I'm going to allow you to get out of jail. You owe the court a total of $858. You owe the court a total of $850. So then we'll switch over to Mr. Holsinger's case, which is case number. So then we'll switch over to Mr. Holsinger's case, which is case number 24. So are you Mr. Holsinger? 483SC. Okay. So are you Mr. Holsinger? On that case, you're here for a fail to appear for a on that case, you're here on September 25th for a creditor's examination on September 25th. Looked like you owed $516 for that. And looked like you owed what I'm going to do $516 for that is I am going to release you on a PR. For that today is I am going to release you on a PR. And we'll reschedule that creditor's exam. Now you're going to get that court date before you leave jail exam. Make sure you get that court date before you leave. Make sure you make note of that. Make sure you make. Make sure you make note of that. You have any questions for me?
No.
You have any questions for me? All right. Thank you, Jail. Next to Raymond.
No.
Okay. All right. Thank you, Jail. Next to Raymond. Person at the Wexford County Jail, please state your name.
Catherine
Person at the
Elizabeth
Wexford
Shedd.
County Jail, please state your name. This is case number
Catherine Elizabeth Shedd.
254712 SD, the people of the
This
state
is
of
case
Michigan
number
versus Catherine Elizabeth
254712
SD, the people of the state of Michigan versus Catherine Elizabeth Shattuck.
an alleged
Ms.
bond
Shattuck, you are
violation.
here on a
It
bench
is alleged
warrant
that you
for
tested
an
positive
alleged
for
bond
alcohol
violation.
on
It is alleged
November
that you tested
16th
positive
of
for alcohol
2025.
I'm sorry, November 16th of
You do have
2025. Right in this matter to have a contested
You do
hearing.
have,
If you wanted to
right
contest
in
in
this
this
matter
matter to have a prosecution, would have to put on evidence to convince the court that there was in fact
prosecution
a bond violation, to convince the court that there was in fact
there
a
is
bond
the
violation
option to plead
or
to the violation, to plead guilty to the violation.
option to plead
You
to the
have,
violation, to plead guilty to the
Mr.
violation.
Hartel,
Your office currently represents
You
Ms. Shattuck, is
have,
that correct?
Mr.
Hartel, your
and
office
how are we
currently
going
represents
to
Ms.
proceed
Shattuck, is
today?
that correct?
Your Honor, she advised me.
And
she
how
would
are
wish
we
do it
going
in
to
person
proceed
today.
today? Is that
Your
true,
Honor,
Ms.
she
Shattuck?
advised me she would wish to do it. in
Yes,
person
sir.
today.
Is
Ms.
that
Dahl,
true,
any
Ms. Shattuck?
objection to that?
No, Your Honor.
Yes, sir.
Ma'am, will you please
Ms.
raise
Dahl,
your
any
right hand?
objection to that?
No, Your Honor.
All right.
Solemnly
Ma'am, will
swear
you
or
please
affirm
raise your
the
right
testimony
hand?
you
Given this matter will be the truth, the whole truth,
solemnly
and
swear or
nothing but the
affirm the
truth.
testimony you
Given this matter will be the truth, the whole truth,
do.
and nothing but the truth. Let me put your hand down.
I do.
So it's my understanding,
put your hand
ma'am,
down.
according to Mr. Hartel,
So
and
it's
yourself,
my
that
understanding,
you
ma'am,
are going
according
to
to
Mr.
plead
Hartel,
guilty
and yourself,
to
that having a positive
going
test for
to
alcohol
plead
on
guilty
to
November
having a
16th,
positive
is that
test for
correct?
alcohol on
Yes, sir.
November
Does anybody
16th.
promise
Is that
you anything
correct?
in order to get you to plead?
Yes, sir. No,
Does anybody promise
Has
you
anybody
anything in order
threatened
to
you in
get
any
you to
way?
plead?
no.
And is it your own free
you in any way
choice to plead?
Yes, sir.
And is it
Then
your
to
own
the
free
allegation
choice?
that you plead, violated your
Yes,
bond
sir.
condition by testing
Then to
positive
the
for
allegation
alcohol
that
on
you
November
violated
16th,
your bond condition by
2025, how do
testing
you plead? Positive for alcohol on November
Guilty.
16th, 2025, how do you plead? Is it true
Guilty.
that the condition of your bond was that you were not to consume alcohol? The condition of your bond was that you
Yes,
were
sir.
not to
And is it
consume
also
alcohol?
true that on or about the
Yes,
16th
sir.
of this month you
And
consumed
is it
alcohol?
also true that on or about
Yes,
the
sir.
16th of this month you
were
consumed
tested
alcohol?
by community corrections?
Yes,
And it
sir.
looks like both the
You were tested by
SoberLink
community
device
corrections on,
and
it looks like
urine
both
test.
the SoberLink
Yes.
device and did both of those come back positive?
Yes, yes,
And did both of those come back positive? The counsel believes the defendant's provided a
Yes.
factual basis to accept the plea.
Yes,
The
Your
counsel
Honor.
believes the defendant's provided a factual basis to accept the plea.
Yes,
Ms.
Your Honor.
Shattuck, I agree, I find you in violation of your bond. Ms. Shattuck,
any
I agree, I
comment
find you in
regarding bond
violation of
moving
your
forward,
bond. Any comment regarding bond moving forward, Mr. Hart?
Continuing her bond. I know that if I recall correctly, she posted a modest amount of injury. If I recall correctly, she posted a modest amount of injury in judgment. I realized that it's the court's error in judgment. I realized that the court raised the court. Takes these very seriously, and I advised her that it would be a race of the court. She did have to post any additional money around the same amount, relatively low. She is of course around the same amount, relatively low. She is of course also aware if the court did give her that grace, she's also aware if the court did give her that grace, we never do that further issues on bond. The prosecutor don't factor that into that negotiations. The prosecutor would factor that into anything, but negotiations that's reasonable to consider her any supervisable if it's reasonable in a situation where that was a supervisable if we were in a situation where that was doing this very seriously and then I do believe she's doing this very seriously and then assess the court to factor that in. Thank you.
Ms.
I
Dahl?
have serious concerns that right after she was arrested, right after she was arrested, she is with a high THC. She is continuing to drink while her breath tests on SoberLink were not as high. They were close. Breath tests on SoberLink were not as high. They were close concerns about her drinking and driving again while she was serious concerns about her drinking and driving again while she was with the conditions already said to ensure that she knew not drink. With the conditions already said to ensure that she knew not drink. I would ask the court to I would ask the court to, and I would ask the court to also add conditions of her treatment, whether add conditions AA or equivalent treatment, whether that be AA or equivalent, to make sure that she focuses every week, and to make sure that she focuses on sobriety and that she's not a danger to the public. Thank you.
Bond in this matter was previously set at $250 with the conditions that the matter was previously set at $250 with conditions substances including marijuana and alcohol or subject to the daily testing for alcohol, marijuana testing for subject to the daily testing for alcohol. The defendant's passed in 22, there was a disorderly drunk. 21 there was a 22, there was a disorderly drunk. 17 there was a 21 there was a 17 there was an arraignment was reported that at least at the time of the arraignment was reported at the PBT at the time of her arrest. The court is faced with somebody at the PBT at the time of her arrest. The court is faced with somebody her second drunk driving, blew very second drunk driving arrest, and according to very high length report, and according to the SoberLink 6 a.m. was blowing at 0.072. 6 a.m. was blowing. The court is going to remand the defendant to the custody of the Wexford County Jail and remand the defendant to the custody of the Wexford County Jail and forfeit.
And that's the reality of bond conditions. The court can give you freedom, but it can take it back just as fast. Some defendants walked into this courtroom hoping for mercy, but repeated mistakes completely destroyed those chances. Justice doesn't always arrive loudly, but when it does, moments like this remind everyone watching why the rules matter.